Okay, let's see. All right, crackling, no crackling. Tell me no crackling. Tell me no crackling. All right, you guys, how's the sound here? How's the sound? Tell us something. No crackling so far. That's good. That's good. No crackling. All right, let's test it. Get Jay in here.
Testing. Hot pocket.
All right. Look, I want to be, the clerk needs us to be clear on your proffer. Mr. Taylor, we have
Sounds like it
exhibit
might be good.
3, which is the
Text message.
the what's now apps. What's
Yeah, come in, babe.
WhatsApp messages. All right. That's document 3, but it's got
Jay's
multiple
crack free.
pages.
Good to know.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
Is the composite.
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want
Well, I'd like to have it on there because
Stip.
they showed it, but they
Yeah.
showed it very
Stip.
quickly.
Oh,
Defendant's Exhibit 5, which is
sorry. Yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Thank you, Madam Clerk, for catching that.
Well, it's,
Right, 5 is in, 3 and 4 are proffers.
when you say, Your Honor, that Exhibit 5 is in, for purposes of proffer,
No, for evidence.
yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible. And,
No, I'm ruling 5 is admissible
okay.
because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of,
Okay, but I think he hasn't. Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just give the prize.
What?
all right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it.
Correct.
What?
I don't know what its status is then.
Are you guys kidding me right now?
What?
All right.
He's offering to accept it. I thought 5 was the whole extraction thing. I'm so confused.
Turn up your gain, babe.
Ay, ay, ay.
All right, so you ready to call your next witness? Ready to bring the jury in?
Yes.
Yeah.
Bring 'em in.
I think we are going to use maybe just open the blinds.
I'm afraid to touch those buttons. Can you hear me?
Yeah, you're low.
Which one, the right or the left?
The one all the way to the left. All the way to the left.
Is that making a difference?
It does.
They just fought over all that, and then both parties said they didn't want it in. Leslie, your guess is as good as mine.
You will bring the jury. You will bring the jury. You will bring the jury. You...
I love when it loops. It's so fun. Looping is fun, Jay.
Do you guys know which Exhibit 5 was? What the hell just happened?
I don't know.
I completely lost.
It's a bunch of Michigosh. I couldn't. I got lost in there
The
somewhere.
judge is like, wait a minute. I just said I would accept it as evidence, but y'all don't want me to take it as
Welcome
evidence.
back, everybody.
What the judge was really
Did
like
anybody
was,
begin deliberations amongst yourselves? Talk with anybody outside of the jury?
oh, wrong.
Do any research or hear anything about anything you talk about? All right. When we were last here, Detective Keyless
People
was,
hearing crackling again. I'm
had
leaving.
finished his
It's me.
testimony, and now we'll let the
No
state
one's
call their
hearing
next
crackling.
witness.
Stay with Paul
You're saying it's echoing.
Echoing.
By the way, thank you so much to everyone who stuck with us and came over
Yes.
here. We really appreciate it.
Yeah, and blame Jay. I'm sure it was all Jay.
This is all my
There's
fault.
no crackling or echoing.
Seems like there
Stop
was a lot
messing
of
with
Jay
me, guys.
issues, like Jay not
All right,
understanding
all right.
technology.
Here's the thing. Can we rewind? Because none of us are sure what happened, and I think people do want to
How
know.
far?
Like whatever the judge was like, how it went from.
Maybe rewind and put it at like
Do
1.5
you
or
want
something.
Keyless to stay under subpoena?
All right, so do you want to see it before he released Keyless? Keyless was the cop doing the extraction. So he was the
No,
one that
because
was
I think I understand the issue was, well, you let the guy go and nobody put it into evidence, so it's not an evidence. He said he'd take it as evidence, and then both parties said they don't want it as evidence, but I want to make sure.
All right, so I'm going to play it at 1.5.
Because I want to give him the right instructions. Yes. All right, can you have Detective Keyless come back in? I'm so focused on getting his name right, I keep forgetting his title.
Just to make you feel better, it took us about 2 weeks to get it.
It just looks nothing like that.
Different.
That's why I didn't.
Sergeant, I'm sorry. Just right in front of me.
Didn't even get his
So at
rank
this point,
right, Judge.
the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what
dare
questions
you,
were asked of them.
Samantha.
And to the extent that this trial is being out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you.
Okay, we're currently playing this back at 1.5. We're behind time. That is
Look,
purposeful.
the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
Text message.
what's now apps, WhatsApp messages. All right, that's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
It's a composite.
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want,
Well, I'd like to have it on there because
Step-
they showed it, but they
Yeah,
showed it very
step-
quickly.
Defendant Exhibit 5, which is
Right, yes.
one of the, I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant Exhibit 5, so that's in.
Thank you, Madam Clerk, for catching that. Well, it's,
Right, 5 is in, 3 and 4 are proffers.
when you say, Your Honor, that Exhibit 5 is in, for purposes of proffer,
No, for evidence.
yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible.
Okay.
Because it was shown. State you showed it.
Right, it was shown.
So this is just a printout of
Well, okay, but I think he hasn't. Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just be the composite.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it.
Correct.
Okay.
All right, so
So what
pause it.
status is then?
Was 5 the Bible verse?
Yes, so pause it. It seems like the defense is saying, well, having 5 alone in does me no good because you didn't let this other stuff in. So I wanted it in as a composite, which it sounds like what they're saying is information that was attempted to get in that the judge didn't let in, and that the defense is kind of trying to be like, well, I don't want that to get in because you didn't let the other stuff to get in, and I want it to be added to like the things that you did wrong. But at the same time, the judge just said he could get it in. So I think, in my opinion, the defense, if they wanted it in, but they only wanted it in if the other stuff was in, they should have allowed it in and then argued getting that in without this other stuff that's not in didn't do us any good, didn't allow us the opportunity to present the defense the way we wanted to. But by saying, well, we don't want it in because you didn't let the other stuff in, I don't know, it seems like they could be shooting themselves in the foot from a waiver standpoint, from an appellate standpoint. I don't even understand why they would have done that. And I also don't know where both Bob, there he is. So, all right, you can pick up.
All right, so you ready to call your next witness? Ready to bring the jury in?
All right, you can bloop bloop and put it at normal time, I guess.
Maybe just open the blinds.
Yeah, I don't think we need to get to bloop, 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 bloop. Oh, there's this guy. All right, I'm going to kick it to normal
I'm going
speed.
to wind up presiding over this case.
Well,
As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the
Nah,
microphone.
no one can
Adjust,
listen to shit like you
does
can.
adjust up, down, left, and right as you need. You can allow
1.5.
clear voice.
Like
You
Bloop,
should
bloop.
crazy world.
I will. Thank you, Your Honor.
Good afternoon, doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
Vincent
And
Vega.
how are you employed?
Vincent
I'm the
Vega.
chief medical examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, do you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And
Good one, Bora Bora.
I'm going to draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And During your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case, of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you the pre-marked that states 86 through.
Can I see the photographs, please?
Yes, they're the same as the ones you just, when you look at that.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
All right, what do we got?
I'm just tweeting this out, the new link, so everyone has it.
That loop.
That's
That loop.
really loud. It's like,
It is?
I don't know, maybe. Oh,
Let me
Yeah,
see.
that was
maybe,
loud.
maybe I had the sound cranked. Oh yeah. I
You
did.
probably had it up for because the Judge Newman one is so loud.
Bring the jury. Yeah, that was the problem. Sorry if I blew your eardrums out.
Yeah, thanks, Bay.
And don't forget,
You're
you could.
welcome, love.
Are we live or could you blippity blip?
Oh, I think I could blippity blip a little bit. Blippity bloop 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 bloop.
Well, she's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge, just bear with me one second. Dr. Vega, we're going to try this one more time. I'm going to show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Thanks for being here, Patricia. We appreciate it.
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you. Your Honor, at this time I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment.
Okay.
Here's one. Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been marked as states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then,
was he laying down?
One were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Thanks, sir. And where would the exit wound be?
Well, no exit, but
I'm sorry, the projectile.
projectile,
Yes, sir.
my mobility is a little limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yes.
So turning.
Thank you, sir.
He had to move, right?
Wait, why are you saying he moved?
Well, I mean, I guess it just depends. It could have been so slightly angled that
And
it comes
you
out the
said
back.
that
I don't know.
the
Ignore me.
wound was front to back. Was it, and from how you showed, and you said it was essentially horizontal.
Yes,
It wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body,
Thank you.
The
So
spine.
his spine.
yes.
And would that injury have been immediately fatal?
Probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then finally you said he was also shot in the leg. Is that correct?
That's correct.
Okay. So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different.
And how so?
Because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast moving awl or punch, in that it goes in and it almost drills a hole into the skin. But when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out. And that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Hard to see. Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
So on me, the entrance was here.
If it helps, I can put my finger there.
Okay. And the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left. And And from back to front, yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any
Right to left
physical
both
evidence
Or left to right? Damn, I should have taken notes.
associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you states 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how you recognize it.
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter states 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of states, this is states 97. Is that the same item that is in states 15?
Yes.
Thank you.
Based on
Did you find
description at opening,
any-
yes.
I'm going to go back to the, well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
So she was
Did
far
you
away.
did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
The absence it reflects the same principle in either injury. And what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated, because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And, Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And was there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Mr. Taylor Cross, and of course the question is, do you need this?
I do not.
Yes, sir.
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice. Thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct. Yes.
Muscular build.
I don't think I use that terminology. I think I just talked about the weight and the body length.
I want to ask you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3-foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his expertise.
I'll allow it if the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
Objection, post-criminal legal.
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because that's asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the length. You've told us that the gun
Bob, you're muted if you're talking, Bob.
Thanks, Jay. Simone, if you're talking about if the defendant can just get up and walk out of the room in the middle of a witness testifying, no, typically not. Obviously, she's out on bond anyway, so during breaks and stuff, she can come and go as she pleases.
But she could
Would
choose, if
have
she chose
had-
not to, she wouldn't have to stay there. Like, I'm not saying get up, like, but like say that she thought this was gonna be tough. Technically, she doesn't have to be there watching his testimony, right?
I mean, they can try her in absentia, you know.
Oh,
I mean,
really?
The
So she
judge would
does
have to
have to be
approve
there?
it for her to leave. If she's saying, I
Oh.
can't sit through this testimony, I want to leave,
Got
the
it.
judge would have to approve. And I think they tried that in Vallow and they told her
They
no.
did. Well, yeah, they tried it in Vallow, or she tried to have it where she didn't have to look at the screen with the pictures of the kids.
Well,
that
that's
they
how
were
she
putting
left
up.
it, that she didn't look, but she tried to be out of the room.
Yeah, she did, definitely.
I could
But
grab
that's
my
different. But
charger.
we've had a couple of trials in recent vintage, like Adam Montgomery, and who was the most recent dude who didn't come to his trial, sat in his cell the whole time.
Tyler Daisy.
Yeah, exactly. Two guys that, you know, the judge couldn't, like, the judge wasn't dragging them in from custody, so they sat in their cell during their trials. So
To have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Baker.
State, any redirect?
Yes. Dr. Vega, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes. So the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr.
This guy had the background to answer that.
Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
So I missed it because I had to go grab my charger. Did the defense even try to establish it was possible that his legs went up?
yeah,
General, we're
he
switching
gave
to
him a
the
scenario.
deputy past 14 and 15.
And he admitted it was possible or no?
He said in that scenario that
Pass,
you
you mean,
presented, it's
yes.
To
possible.
the jury.
Sorry,
Wasn't quite sure what you
Essentially,
meant.
a scenario where he falls on the ground and his leg goes up in the air.
Right, it doesn't have to go over his head. It just has to be higher than.
He
Well, it
didn't
has to
say
be higher
over
than
his
her
head. He
gun.
said he just fell and his legs would have gone up, and she shot him at that point.
But in theory, it would have to go high enough where first she was standing to make the chest shot.
Court state, your next witness.
It was
Daniel
legs
Houseboat.
up.
I hope the state has someone like Dr. Kinsey who can give me like that's not enough for me. Like I need someone to really show me how they think this happened, because that's like
The defense, I think, needs to pull that together. I mean, maybe not. Maybe that was enough. I don't know. We'll see.
yeah, exactly, Amy. Dalrod and Dr. K agree.
Just doesn't seem like the guy to me.
I thought the state was done after one witness today.
No, three. They had three. I think this is the last one.
Do you solemnly swear or affirm the testimony about to give the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Hello, sir. My name is Judge Wright. I'm presiding over this case. As the
Exactly,
deputy said,
trial
just make
daddy.
yourself comfortable in
Or
that chair.
crash
Scoot up
daddy.
just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just keep it loud.
Hey, I
clear
hope
voice, it
everybody
should
hit
be okay.
the thumbs
thank
up
you.
for this new stream so it
Good
gets
afternoon.
Good afternoon.
Could you state your full
play.
name?
Hold on one second.
Oh, I'm sorry.
Hit
I
the
think we
like
Go
still
stream.
need,
You all
like,
finish up.
there's
So
100
wait
and
a
some
second.
people
Yeah.
here who
I
haven't hit
apologize,
like.
Judge.
I don't want anybody to feel rushed. But like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Creel.
Thank you, Judge.
170 of you.
Please state your
haven't
full
hit
name
the
and spell your
thumbs up.
last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorff.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearm section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
I'm watching
And
those
you
thumbs up go up. People
well,
are
we're gonna get
listening.
there, I'm sorry.
Thanks, y'all.
What
Good
training
job.
did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August of 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but that an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases for firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given the unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case, and everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials and my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check these safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
Yeah, it's empty.
I was going to say there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorff,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then like the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it will go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Mom. Can we put it for a moment?
Of course.
See what we got. Bloop,
What is this approach all about?
bloop, 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 bloop. Wait. Is bloop, bloop, bloop,
Okay.
And that there was a live round
And it'll
release.
bloop, bloop, bloop.
Mr. Hausdorff, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extraction groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were
Because
not
he was holding
seated
it firmly.
and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLE case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just so
Yes,
we can
ma'am.
talk about that part?
Yes.
We're really going. And so you said you first look at test to test, and can you explain slowly
Yes,
how what you're looking for to compare those to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
I wonder why she didn't
Thank you.
end with the other guy. He's much more interesting.
Who, the
Unless
ME?
there's
I
like
want to now show
some
you
bombshell that's coming from
states
him.
8, 9, 10.
The ME?
Yeah.
And 14.
Unless
Julie,
there's
take a
something
look
going to
at
come
these
from this that
items.
I'm not anticipating right now.
Thank you.
And tell me if there are items that you previously seen in your lab.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact. So I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
No, I think the first time you said fired in and then you said fired from.
The
What's
reason
the
I just say in is that cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical.
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value for microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received one t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material.
I guess they think it's more
is it will
important
create
she was
basically
far
sooting
away.
around the hole,
That's what he's
and
getting into.
it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was unable to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is states too. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
Thank you. And when you
the shirt.
examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to
Me too,
find
Kai.
stippling on a shirt if those other
I
factors
was
were
a
not
gymnast,
involved?
though.
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
I went through and just clicked record on gymnastics
I
for
don't have anything
the
else for
Olympics.
the defense ma'am. Thank you, sir.
Thank you.
And I don't even want to watch the men's gymnastics. I only want to watch women's
Very
gymnastics.
briefly, so Mr. Hausdorff, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Are you sure?
Yes, sir. Thank you.
Are you
Can this witness be released?
What the hell did she in with this guy?
Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you.
all right? Well, we're about to find out if the state rests.
State,
Your Honor, at this time, the state rests.
Wow.
members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics you've heard anything about. Don't speak with anybody else outside of the jury about this case at all. All right?
I have to say,
Leave your notes.
You can blippity blip.
she should have been allowed to assert her.
Worried looks on your face. When I just sent them on an afternoon break, I could see some worried looks on your faces it's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day.
And motion for
I
directed
saw
verdict.
I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument.
Judgment of acquittal.
So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, I want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm looking back through my notes. We've still got the issue of Vicky Mechanic, trial sub, and Richardson hearing.
So he's saying they're not going
We've
to have any
got
more
the
testimony.
issue of Daubert and
Yeah.
what's his name? Bliss, the expert.
Ferris.
Ferris.
Ferris, Ron.
I don't know where I got Bliss.
He's a police
You
officer.
smushed them together.
Okay. We've got that, and I have another Richardson issue. It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own
Impeach.
her own explanation for them,
Yes.
Which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And there's one other matter.
Oh, all right.
In an effort to protect Miss Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday. So I've already heard from Miss Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
You can't tag from
Okay.
a phone.
Well, I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So we're going to kind of give you all the option. If you want to, I can give you the break that I'm giving them. You all can talk about, do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay.
Yeah.
All right.
I think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now.
He wants to go to his motion right now.
Early, I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just want to clarify.
Sorry.
Thank you.
Well, yeah, I think let's at least get that done this evening.
Yes, all right.
Wow, we're about to go to
That was
hearing.
gonna be, I was trying to figure out if you meant
Or
JOA.
motion argument,
JA.
sorry.
Yep, sorry.
So
Yeah, I
now,
mean, they always do.
I know, but I thought he was going to wait. The judge thought he was going to wait too.
let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do. And then we can hit the ground running tomorrow morning. Just so you know, because as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, a 33-day motion, I'll have to hear first thing. If it hasn't been obviated by the filing of the information or a null pros, I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
12 minutes. Let's see how much we got. I don't think we have that much.
I mean,
Oh yeah,
I
there's
hope the
way more
defense
to
is
go.
thinking before, like, they're going right into their
Oh.
motion.
Word.
I think that they got something out of the medical examiner they could use, and that it could have been him running, but it also could have been him.
What do you mean? The fact that he was shot in the back of the leg?
Right. And
Yeah, I mean,
I'm surprised the defense didn't object to that person who was not like an expert on like motion or whatever the hell, I don't know if it's
Yeah, like a Dr. Rensler from
Right.
Reed,
right.
biomechanics guy.
That his legs could have gone up, but
Yeah,
obviously
biomechanics guy. That's like, I mean, the defense might have somebody like that. We don't know.
no, but I'm saying that they should have objected to the medical examiner saying whether in his opinion the legs would have gone up.
Well, could have gone up.
Could have, but whatever. The state.
It's never easy, Your Honor. We have a witness issue. Faith Brown is available now, which is not available tomorrow.
They want to put on their first witness.
A long witness, which the court would entertain. However, Your Honor wants to do it, while we have the jury here, I can call her. Or
Before you KOA?
case law even says the Supreme Court case of Stacey Smith, the court could call her as a court witness. And when she's done, then we could do the JOA or we could do it reverse.
I'm sorry, did you say she's here?
She may be outside now. She was on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't
She's not
know about
listed
her.
with.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state. That's the other subject of your
Yes, it
Richardson
is
hearing,
actually.
is those emails from the sealed hearing that we've now had access to. I think it had to have been obtained by the defense from Ms. Faith Brown, and because the state's never got this until yesterday.
What was the date, September 30th? Which one?
Now, Judge, those emails came from the state.
You're gonna have to show me where, because
I don't
I
know.
looked at my.
Well, we don't need the back and forth. I'm trying to figure out.
I don't know.
He's trying to wrap his mind around the JOA and the calling of a witness for the defense before ruling on that, I guess. But
Listen, this is for me, who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done,
I'm going to say don't put your witness on yet.
what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be outstanding out here.
My first one of the trial.
No, that really would work out pretty well because I got witnesses like planes stacked, and my head is spinning over it. So yeah, that would.
And just so you know, State, this is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was,
What happened
I
to
can't
that
remember what the other
question
one
about
was.
JOA? Did I
Then
do
you have
something
the
to it?
entire weekend to go through everything. And
Judgment of
we kind of
acquittal.
hit reset, and then defense, you can
Explain it more
come
after.
forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors, I can't remember.
No,
There were conflicts that started next week.
But I don't know
I'm
if
not
it
sure what they were.
started Monday or Wednesday or.
I think the juror that, the gentleman we had last today, he had a conference starting Monday out of town. Not that we would be done tomorrow anyways, but.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
Right, but does that mean finish Monday or finish Tuesday?
Oh, definitely
Define
don't,
finish.
definitely don't finish Monday.
All right, so defense case done Monday. And
Then
then
we
you,
close Tuesday.
and then you,
That'd be the-
I think that might be optimistic.
I
I
thought
think
he was saying-
Wednesday probably is more realistic.
I thought he said he
right,
wasn't
so
going to
finish
Monday.
defense case
Right.
Monday,
That's what I
but
heard.
then we have jury instructions.
Right.
Oh,
I
thought he said
I
Right.
he wasn't
apologize.
going to be finished.
Right. Why doesn't he
So you
speak up?
expect to finish Tuesday?
Yes.
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
Which means he can't finish it on Tuesday. No way.
Right, Wednesday. Just I don't know why they set
Yes, I mean,
jurors
you're
conflicts that quick.
correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, and I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
Right.
we can try to finish the case up Tuesday, if not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I don't make the final decision, but that would be my opinion, is to not go a full day without doing any trial tomorrow, but.
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Just one.
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information was filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock. And then we start the defense's case in chief around 1. And go as far as we can. Okay?
No one's saying anything.
You're nodding your heads, but yes.
Sorry.
All right, so
Heard
if
the
you
meeting
could,
changed
let's
the jury
bring
not
the
being
jury
there.
back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with a goal of having them up here around 1 o'clock.
All right, so, I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
On Monday.
Well, if she's not available tomorrow,
She's not. Is she available Monday? No, she's out.
I'd say maybe call her Monday.
Yeah, that'd be fine. I
Mr. Harris, she's not available.
I just want to make sure she's available.
Sure.
Yeah.
Right, or is she under subpoena?
No.
Oh. Ooh.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed, seems outrageous.
No, hold on.
Okay.
This is me, because I want to get these, I got a bunch of hearings that I got to get done,
Okay.
including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done.
It's outrageous, egregious, preposterous.
Did he step out to ask? What's he asking?
You want me to bring her in?
No, I just need to know, is that the plan?
Yeah.
So, because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we can put her on today, then
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
okay.
Not available Monday. Not available tomorrow. Nope.
Can you give me a moment?
Of course.
He's gonna go out and tell her, well, that's not gonna work.
A bunch of
No flipping.
flipping.
You want me to blip? I'll get some blipping. Blip, bloop, 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 bloop. All right, slider. Sliding. Slide up.
I'm happy to report, Your Honor, she will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
State's not going to be happy still.
Right.
So we're going to do all the motions this afternoon?
Yeah.
Thank you, Judge.
Yep. And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements
I
now?
would, yes.
But while you're doing that,
Yeah.
can one of you stay?
Yes,
And I'm going to tell the jury 12:45 tomorrow?
Let him go.
Well, no, wait a minute.
Right, now we can have them here in the morning.
Now I need them here in the morning.
Yes.
Okay, all right.
What a clusterfuck. Jeez Louise.
Hold on. I just
I
want to make
mean,
sure she's going to be.
Kind of par for the course in a trial. It
You
happens.
guys have every
Yeah,
right,
so-
and should be able to speak with her about her expected testimony.
I'm curious to know who she is and why there was such a late disclosure.
Isn't she
must
the
have
one
missed
trying to
something.
get the divorce? What they were trying to get in the other day, where about the communications? Do you remember there was like the
Emails.
hearing that only the defense had and the prosecution didn't? I think maybe I'm wrong. I don't know.
Maybe but I don't know. But I mean, the state's crying foul because they're saying there was no disclosure prior to trial, that this disclosure happened after trial started, that they weren't tendered any discovery, that they'd never had a chance to depose her or speak to her. So I don't know who she is or what the hell she's going to testify about. But you might be right, Jay. It could be relating to those, various documents they're trying to get in, whether it be emails or whatever the case may be,
All right.
or
While
those
we're
text
doing this,
messages they were
let's
talking about.
re-explain the burden. Okay. So the ultimately, so long as the defense puts some evidence forward that she was in fear, then the state has to prove beyond a reasonable doubt it was not self-defense. So it basically, as long as and they've put some stuff in, and he took kind of issue with whether they can prove it during the state's case, which in my experience you can. Maybe in Florida you can't. I don't get the difference. But as long as she raises some evidence that she was in fear, then the state has to prove beyond a reasonable doubt it was not self-defense.
And the defense's burden is only preponderance. It's not beyond a reasonable doubt. So they just more likely than not type situation. And as long as they meet that standard, which is obviously much lower than beyond a reasonable doubt, then the burden shifts back to the state. And then, as Ali said, they have to prove beyond a reasonable doubt that she was not justified.
But the jury just gets told the state has to prove beyond a reasonable doubt it's not self-defense, unless the judge finds that she didn't put on anything even to raise the issue. But it's very little that has to go in for that.
Okay.
Did that come up during your conversations?
It might come up, but I'm sure she'll talk to the judge.
Go ahead.
Bloop, bloop. Got any blooping?
Blooping? Yeah, Bora Bora, I had read those 4 elements when we started the stream earlier. Bloop, 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 bloop. Bloop, 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 bloop.
It's an issue that Your Honor's going to have to deal with. She was not under subpoena by either side, and was not told that because she wasn't expecting to be witness that she could not observe the proceedings. So she has watched some of the proceedings. Once I contacted her, told her that we needed her, we told her to stop, and of course she was conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now. I'm just, you're on notice. We're just waiting for her, Ms. O'Donnell, to come back in and confirm that we can you guys can speak with her tonight or tomorrow. Yeah, for tonight, the other.
Okay.
Bloop, 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 bloop.
Start at 9.
Sorry, Judge, I didn't realize you needed me to come back.
8:45, start at 9.
Sorry, Judge, I didn't realize you needed me to come back.
No, it's fine. Don't worry about it. Yes, bring him in.
Bloop, 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 bloop.
Back every. Okay, so there are some things that we need to do on our end, and the reason I gave you that break was to have a conversation with the attorneys and kind of make a list of everything that we need to do before we can move on to the next step. So what I'm going to do is we're going to stay this evening and keep working, but I'm going to let you all go for the evening. So remember, please don't discuss amongst yourselves anything about the case or begin deliberations. Don't talk with anybody outside of the jury about the case. And please don't do any research on people, places, things, or legal topics you've heard anything about.
Got any time left, Bay?
Tomorrow, if I could have you downstairs in the jury assembly room at 8:45.
Listen to Judge Hot
And
Pot.
we're going to have a goal to start up here about 9 o'clock. Figure if we stay late, and then some things tomorrow morning, we should be ready to get going then, okay?
Yes, sir. Okay, thank you.
All right, thank you. Just fold up your notes and leave them right there on your chair. We'll see you tomorrow.
Oh, man. You're so easy, babe. You're so easy.
Good night.
Okay, I'll give you some
What's she trying to say with her
All right,
eyes?
State having rested defense. Your
Here we
jail.
go.
Go. So he is asking the judge to find as a matter of law the state has not proven their case beyond a reasonable doubt and to enter a verdict of not guilty or a judgment of acquittal.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call, wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit.
The judge.
For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 9/11. And 9/11, of course, is what you do to summon help.
911, dude.
And
911.
there has been nothing indicated otherwise
Keep
that
messing with
Ms.
that number,
Benefield
New Yorkers.
displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is he attacked me and I shot him. There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield. And if they are properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden.
Could conclude, well, could not conclude
The
they did.
self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintel, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th.
That's not in evidence yet, though, right?
The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this: 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that?
I remember that.
That other than sheer speculation, trying to roll an inference and an innuendo into a fact, where's there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State?
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as
Really?
they've come out. I believe a lot of what he said, witnesses
No
said,
way.
were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind.
Wait, I thought she shot the weapon 4 times, but he was only hit twice. Isn't that the actual fact pattern?
I think
Or am
so.
wrong
I
on
think
that?
you're right.
Surprised you didn't jump up and say that was some bullshit.
Regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there is also spite or evil intent. And that is disjunctive, so it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time, and she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said that this was the same exact judge that she had not had luck with before. And implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side.
That is not what your expert said.
Turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away.
And calls for help.
And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that defense just argued have not come in as evidence.
That
so
might be
in the
true.
light most favorable to the state, we would ask you to deny the JOA. Thank you.
Mr. Taylor, would you like to place any rebuttal on the record?
Very briefly.
Yeah,
Thank you.
about the
Well,
front,
briefly.
not the side.
No, briefly. So here's what we have according to the state. We have a woman who
Yes,
is
Jessica.
going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance is what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick.
I was thinking the same thing.
I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed and failed miserably to rebut it.
Come on, say the thing about front to back. Front to back.
And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right. Thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
No. Okay. All right. I just want to make sure. So.
Come on, Josh.
No, because
What?
that's what the defense argued.
Oh, okay.
Again, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief.
I'm going to research this.
By a preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. You're going to see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson. You're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it, I might be mixing apples and oranges. Something was 390 and something was 316. And
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing. And based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an
The
email.
auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said, I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. And the beheading, forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is? 277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies or at least clue me into where it is and what exact pages are intended to be entered. And that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
Do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified
But
something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at a trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of the doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony. That can't be right either. So we have to find the happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. But I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said on page 4, I have an envelope to seal this if necessary. I have Ms. Murphy's stand your ground testimony that I will pass to the court.
You might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking. That was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, was he turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about Vicky Mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had And whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Miss Murphy and Miss Brown as meaning different things? Could it be received by the jury to be substantial in their decision making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was documents, we could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently. But I just, at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Faith Brown because she was not listed.
Yes. Okay. Do you want to be heard on that?
Can we just have a minute? We were just
Of course.
discussing.
Got any bloopage, roomage?
Let me see. Let me see what I got. Let's see if I got some bloopage. Bloop, 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 bloop.
He's talking.
Oh. Bloop.
Well, now that you've seen my order,
Where they were
Bloop, bloop,
in the light most favorable, in our mind, concern,
bloop, bloop,
these emails.
bloop, bloop, bloop.
Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that along with these emails, that it feels a lot like sandbagging to the state.
Sandbag.
Ambushes, I think your judge, as your honor called it. And that was our concern. But in the light most favorable, in our mind, to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed,
Yes.
I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir. And
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email,
Scott,
you never
coming in
authenticated it with her.
Thank you so much,
You never
Scott.
laid the predicate.
Thank you.
And I
Venmo
was
style.
waiting and waiting and
Our
waiting.
favorite.
So I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing on calling of Ms. Brown.
Yes, yes.
So hold off on mechanic subpoena for now. The argument about it.
Yes,
Okay,
I
well,
think so.
I'm just going to put that on the back burner for now. And
I suspect that's going to be resolved.
we still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on, but I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
How many pages is this thing?
If it does, Your Honor, I would ask that you
Skip that.
respectfully.
Fair enough. No, let me look. I don't think it does. All right. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions they'll be asking. It might be Monday. I don't know.
Wait, he's doing it like as
One of
a
the most important and fundamental constitutional
one?
rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended. I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client
I feel like we've heard him
trusts
do this
that I
before.
have her best interests at heart. And I think that this
He did this pre-trial, made the same.
unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making the choice after consultation with her attorney. And this is just piling the pressure on the client.
What?
I'm sorry, Your Honor. I find it uncomfortable.
You wouldn't be heard for right. I mean, it's my
I
decision.
would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes the decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say. And if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So if you say, hey, don't answer that, okay. But I'm going to have it on the record because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify. My lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask, make sure that nobody's threatened you, forced you, or coerced you to make this decision, that nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it. And if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it. And then we'll have that conversation either tomorrow or next week. All right. Anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right. Well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course. Absolutely.
Were there two bald guys?
Yes, apparently, yeah.
We've never had a judge not give a colloquy or admonish the defendant.
Yeah, I thought that was bizarre.
Strange.
Are we live or are we
No, I'm gonna bloop it.
But they're not even. Oh,
Request withdrawn.
Okay.
request withdrawn. Good.
Wait, what was,
All right.
which one? The one about
Anything else we can talk about
Ex parte
today?
thing.
No?
What time are we starting tomorrow? 9, she said that.
Where's my list going? Let's shoot for 8:45, just in case there's any last minute stuff. And then with the goal of starting at 9.
And is the plan then to have
does
testimony all
not
day?
need to stop
Oh,
right
yeah, I
now.
think so.
Okay.
Right, we're gonna have them lined up one after another, ready to go?
Pretty much.
Okay.
Okay, so there we go. So much for the off day tomorrow.
I know. I was excited about it.
Me too.
All right, we'll be there off the record until tomorrow
Just
morning.
doing somersaults in my head, relaxing. All right, I think we might be done here, huh? Boop 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 boop. Yep. All right, that's it. All right, day 3 complete. Complete. All right.
That was
so
a day. Amy. It was a day. What a day.
It was a day. It was another day, another interesting day. All right, here's the best potato chips right here, Jay's, right there. Look at them, and they're your namesake, for God's sakes, dude.
I mean, I like that, but I don't know if they're better than Utz, though.
Excuse me.
I don't
Excuse me,
think
sir. You've never had an
Allie
Utz
knows.
potato
Allie
chip in your
knows.
life,
Utz.
Allie.
Yeah, I'm
We just
from the
have
East
we just do
Coast.
Utz pretzels.
Utz are
No, no.
from like Pennsylvania. I'm pretty
Yeah,
sure
they're
like,
East Coast. I've had Utz chips.
You
do they
are
even have
so-
ripples? Where's like the ruffle version?
Right. Where's the ruffle version?
Are you questioning Jay's? Hold on.
I am questioning Chase because I don't see.
I need ruffles in my
You
chips.
guys,
Yes,
all right,
thank you, Allie. No, the Utz ripples are the best.
all right, now pipe down. Here's all that they got: the Jay's Crunchers, the
Still
sour
don't see.
cream. Relax, calm down.
There's the
Oh, you're
Lay's.
listening to
Jays,
Lay's.
get out of here, Jay. Sorry, Jay. You've stolen my name. I'm gonna make a copyright claim. But
They
you
have
know what
they
I
have
mean?
crispy ridges.
Oh,
all
there's
right, I guess.
crispy ridges. All right.
Okay.
Crispy ridges. All right. So now you know. Now you know. All right. So another successful day of streaming. Kind of. We had some technical difficulties. Most of y'all found your way back, which we appreciate. We appreciate you
thank
guys
you.
hanging with us through.
I actually don't think I've ever had
Utz.
Utz potato chips. Now that I'm thinking about
What?
it, now that I'm
Really?
looking at the bag, now that I'm looking at the bag, I'm like, that's
Yeah,
not
I don't
something I've
think
ever
so. A
eaten.
lot of pretzels, a lot of Utz pretzels, but I don't think you had the chips there, babe.
But the ripples and the whatchamacallits,
The
yeah,
ripples,
yeah, but
ruffles,
ruffles, yeah,
ruffles, yeah.
ruffles.
Exactly. But yeah, thank you guys so much for hanging with us. Thank you, mods, for all your hard work. Once again, as always, we love you, we adore you, we appreciate you, all the things that we can feel towards you that are wonderful. That's what we feel. Jay, you're amazing. I love you. We will be in Jay's neighborhood tomorrow. So make sure you guys are hitting your notifications. If
Shannon
you are
will be
new
joining us.
to the stream today. Oh, I'm so
Oh, and
excited about
Shannon's
that.
gonna be there. That's right.
Not the whole day.
We're
but
gonna have
she'll be
a
joining us.
we're gonna have a impromptu double date. I love
Yes.
that.
No,
I
I
love that.
think I was thinking I'd be out while Shannon was in
Why you gotta dip?
because it's
Maybe
I
Jay
want
and I'll
Shannon
dip
to.
out and you and Shannon will handle the stream. How about
Yeah.
them apples? Yeah. Yeah.
I mean, go
I
for
bet
it.
you the ladies in the chat
Chat
are
would
gonna
like that for sure.
concept right there. But so if you guys have not, if you're new to our channel, please share, subscribe. And if you have not already subscribed over to Jay's channel, please go over there. Do that today. Hit notifications. It's hit or miss with YouTube, but they sometimes get you notifications when we go live. If you're looking for a place that always is going to have all of our channels information, you go to Seeking Justice Discord. Tracy and Dizzy have an amazing Discord channel over there. What do they call them? Not channels. What do they call them? Discord. It's got a word. It's a different word. But if you go over to Discord, they have an amazing Discord.
Oh my
It's
God!
got not only updates in terms of notifications of when we're all going live, but it's got every document from every case that we're following that you could ever want. So it's phenomenal. So all right, man. So what? 8:40? You said 8:45?
8:40. Yeah, I'll set up for 8:45 tomorrow.
Okay. Scott Kohler. I also got a $25 Venmo.
Scott, you're the best, Scott.
Dude, that's amazing. We just love Venmos because YouTube doesn't get their fingers on it. So thank you, for the great YouTube stream. We appreciate you, Scott, so much. Thank you a million times over for that. Got anything else, brother?
No, just thank you all for sticking with us through those technical difficulties and coming and sharing it out and doing all the things. Tell your friends, tell everyone. We'll be here tomorrow, be on my channel tomorrow, and then we got the weekend. So thank you all. Oh, quickly, Publicly Buzz tonight. Don't miss that, guys. There'll be, I believe, at 8 o'clock. Don't miss Publicly Buzz stream.
Yes. Speaking of which, what time is their thing?
I think 8 he usually does, I think.
What? All right. Okay, we're about to dip. All right, hold on. We love you guys. Yeah,
Thanks,
don't
everybody.
forget to hit PB tonight.
Go
please.
Mets, Catherine. Go Mets. LFGM.
All right, we'll see you later. All right. We're gonna give you the outros. Boop. We love this one. See y'all.
Thank you for joining us, J-Bo Nation. Please give all of yourselves an ovation. No, it won't be real long until next time. Oh, J-Bo Nation, there's no place we'd rather be. J-Bo Nation is the place to 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 be.